name is Sarah Meyers. I'm an attorney with the law firm of Ania Scanlon and Sirignano. Welcome to our weekly elder law program from Ania Scanlon Sirignano. This week we're talking about what happens when a person dies without a will. We're going to be demystifying the estate process, both estate administration as well as probate when a person does have a will. I've created for you a chart of what happens and who inherits if a person dies without a will. One of the biggest misconceptions is that when a person passes without a will, the quote-unquote state will take that person's money. It's a common misconception, but it is not true. What happens in New York State when someone dies without a will, is we follow the rules of intestacy. New York State has a statute that determines what happens and who inherits, who are what are called the distributees, when again a person passes without a will. So I've made a chart for you. Hopefully you can see it a bit. I know I've just covered my face. When a person dies, leaving a spouse and only a spouse with no children, the spouse will inherit 100% of that person's assets. When a person dies without a will, leaving a spouse and children, the spouse will receive the first $50,000 of that person's estate, and then the spouse and the children will each divide up the remainder 50%. So 50% to the spouse, 50% to the surviving children, to the children. If a person dies with no spouse leaving children, the children are the distributees and they inherit and share amongst themselves from their parents' estate. If a person in New York State dies without a spouse and without children and without grandchildren or children of their children or more remote descendants further down that line, the rules of intestacy first follow. We look to the parents of the decedent to see if the parents are alive, and if not the parents, the decedent's siblings, and if not the decedent's siblings, the decedent's children, so the person's nieces and nephews. So we have the rules of intestacy. What also we have in terms of the rules of intestacy is who would be appointed the administrator of the estate, the person to handle the estate, to file a petition with the surrogates court, and to again be in charge to be the fiduciary of that estate. So what happens first is the spouse of the individual, if he or she is surviving, would have the priority to petition the court for what are called letters of administration in order to be the person to have authority to receive authority from the court to be the appointed fiduciary of the estate. Again, and if there's no surviving spouse, it would be the children of the decedent, if there are any, who would then have the authority or the standing to petition the court for letters of administration. Once the assets of the decedent are marshaled, the only assets that fall under a probate, which is when a person dies with a will, or an estate administration, are those assets in the decedent's name alone. Any asset titled jointly with another, or that has a named beneficiary, or is titled to a trust, does not pass through the person's estate or will. That would pass to the beneficiary or the joint holder on that account. So only assets in the individual's name alone would pass through the estate and would be administered. After paying all of the estate expenses, funeral expenses, and other expenses and debts of the decedent, the administrator of the estate would then distribute the assets to the distributees of the estate, right, because they're no named beneficiaries. So to the people who inherit under what we talked about before, the rules of intestacy, as demonstrated in the chart we created today. So if the decedent is survived by a spouse and children, the spouse would receive the first $50,000, with the remainder being divided equally, 50% to the spouse and 50% to be divided up among the children, or for child predeceases, to that predeceased child's children if he or she had any. So they're one of the negatives, or one of the reasons why it's so important to have a will, is that you can then determine who you want to inherit from your estate and how you want them to inherit. So for example, if your children are all minors or children are all under the age of 20 or 30 or 40. If you want them to receive their share in trust until a certain age, without a will, there's no provision for that because they would be inheriting as the distributees their share from the estate. But when you have a will, you can say, look, if I have children, if a child is under the age of 30, I want them to receive a certain percentage at 30, a certain percentage at 40, a certain percentage of 50. So you have much more control as to how your assets are left and are divided upon your passing if you have a will. Again, there's much more control. It doesn't look towards the statute in what's called the SCPA, the Surrogates Court Procedure Act, or in the EPTL, the Estate Planning Trust Laws. So it's very important. Again, if there's an opportunity to have a will, it gets to dictate how you want your assets to pass without having to look to the rules of intestacy, without looking to the state and how those should be distributed. It's also important if you have children who are minors to have a will, because when the rules of intestacy, when there is no will, don't cover who should be the guardian of your child or children if they're under the age of 18 upon your passing. So it's also very important when you have a will, and then in that will, if your children are minors, to designate who should be the guardian if you and your spouse should both pass and you have a child or children under the 18. So again, in these uncertain times, it's so important to have some certainty and to be able to have control over your assets upon your passing, to first know that they go to the people that you want to designate them to go to also know that there's a guardian that's appointed for your children that you then name in the will, and that's the person that you'd be choosing. Also, if you wanted assets to pass in a certain way, in trust for a surviving spouse, in trust for a child who might have a disability or a mental health issue. So it's important to be able to control how those assets can be given to your beneficiaries under a will. You also might want a specific bequest. You might, for example, have an antique car that you want to go to one child or another, and that would be then a specific bequest that you can leave in the will to basically say who you want that specific asset or that specific piece of what's called tangible personal property to go to. So again, there's much more control when a person has a will. And again, as I said before, it's so important, especially in these times, to make sure that your wishes are accomplished and assets upon your passing go to those people or persons that you designate. But again, as we said earlier, if a person dies without a will, in New York State, we follow the rules of intestacy. So first, the legislation, the statute says how your estate is divided up. But again, it doesn't offer protections in terms if you want assets going into a trust for a child or for a spouse until a certain age, for a child or grandchild with physical or mental disabilities, or perhaps unfortunately a drug addiction. You want to be able to protect those assets and have them go to your beneficiaries, to your children, to someone other than your children. You want to be able to specifically bequest them. There are always questions in terms of what assets pass through your estate, either probate through your will or through an estate administration. And we touched on this a couple of minutes ago. Only those assets that are in your name alone upon your passing are passed through either your estate through an administration if you die without a will, or passed through your will. So, for example, if I have a bank account joint with my husband and I predecease him, that account, when I pass, is not part of my probate estate or my estate administration because it's held jointly with my husband. It passes to him by what's called operation of law. If I have a retirement account, a 401k or an IRA, if it has a named beneficiary, that account passes to the named beneficiary upon my passing. If I have a bank account that's in trust for or payable on death or transfer on death, my spouse or my kids, upon my passing, also by operation of law, that account will pass to that named beneficiary, that designated beneficiary. It doesn't pass through my will. assets that are in my name alone at the time of my passing those are the assets that pass through my will. There are always questions in terms of real property. And upon passing, if the real property, if it's held jointly, if the asset is being held jointly, whether that asset, the property, sorry, I'm just assuming I just got a text that someone can't see, but I do see that there are people watching, so I'm happy to see all of you here. I have been, sorry. So we're talking about real property. So the deed on a real property should state, for example, the husband, this property is owned, the deed has the names husband and wife. In New York State, it is assumed that if a deed has both husband and wife on it, it's owned what's called by tenancy by the entirety, and which is like right of survivorship. So if one of the owners passes, of the husband and wife, again, the surviving spouse, the property is owned by him or her without having, by operation of law. An issue comes about with shares of stock in a cooperative apartment. So, for example, if my husband and I own a co-op and the shares of stock were titled to, Sarah and Kenny, if we purchased that co-op before the mid-90s, the co-op assumes that 50% of the co-op belongs to my spouse and 50% belongs to me. So on my passing, my 50% would pass through my will, or if again, no will, through the rules of intestacy. So with shares of stock in a cooperative apartment, it's important to make sure that it's titled joint with right of survivorship, if that's what your wishes are. And if it is joint with right of survivorship, like a deed or a joint bank account, it would only be on the passing of the second spouse, the second to die, that asset would become a probate asset. My partner Anthony Ania spoke last week on our Facebook Live about the use of a revocable trust and an irrevocable trust in terms of estate planning and avoiding the probate process. So the probate process, let's talk about just what happens when a person dies in terms of an estate administration or a probate. What happens is if there's no will, and a petition for estate administration is filed with the surrogate's court, so if we're in Westchester County here, it'd be filed in Westchester County, along with an original death certificate of the decedent. It will be filed by someone, by the spouse or by the child, stating that so-and-so passed. Here's the original death certificate. Here's an administration proceeding that I'm seeking to become the administrator. This is my parents, the name of the spouse. These are my siblings. We are what are called the distributees. And there's a form called a waiver and consent saying we're all in agreement. We have no issues that someone should be the administrator, and we want the court to issue letters of administration. The court to issue the letters of administration, which is the authority for the person petitioning the court to be the administrator of the estate. In a probate proceeding, a probate petition is filed with the court along with the original will and an original death certificate. The petition is filed by the person named in the will as the executor of the estate. The decedent, if he has or she has a surviving spouse and or surviving children who would be the distributees in an intestate proceeding, all have to sign something called a waiver and consent. Well, if they're not contesting the will, saying we agree with the will, we have no objections to it. Court, please admit the will to probate, and we have no objection to the executor acting as the fiduciary, as the executor of the estate. What happens at that point is the surrogate's court processes the paperwork and letters of either administration if it's an intestate, or letters regarding the probate are issued to the executor or administrator, giving that person the legal letters testamentary, my apologies, legal authority to act on behalf of the estate. In both cases, the fiduciary, be the administrator or the executor, at that point starts to marshal, to gather the assets of the estate, opens in a bank account in the name of the estate, from which he deposits the decedent's funds, from which he or she will pay bills, pay the funeral expenses. If there are any creditors of the estate are paid from then too. And then after all the bills are paid, the expenses are paid, and after 7 months, the administrator or the executor can make distributions to the named beneficiaries under the will, or to the distributees if it's an intestate distribution, if there is no will, to the beneficiaries or to the intestate distributees under the last will and testament. So again, there's much more control of your assets when you do have a will, unlike intestate, because with intestacy, it's formulaic. It's okay, let's look to the statute, let's look to see who's surviving. Is it a spouse? Is it a child, grandchild? Are there no children, grandchildren, no spouse? Who are we looking to inherit, to receive those funds? So unlike that with a will, the person can make, the decedent has already made the decision under his or her will on where he or she wants those assets to go. And many a time, again, if there's a disability, if there's a child who's estranged, if it's a second marriage, there could be different provisions under the will, which again, that person then has control of, and how those funds should be distributed. And again, it's also very important for parents or parents with a child or children under the age of 18 to appoint a guardian for that child. God forbid, both parents should predecease before the child turns the age of 18. And again, these are always very important conversations to have with parents, with children, with family members as to what those wishes are, how you want things handled upon your death, and again, to make sure your children, your family members are on the same page and understand what your wishes are, and to be very clear with what your wishes are. It gives a lot more certainty, always, but especially in these times, for everyone to know and for a person to know that their assets are being taken care of the way they want them taken care of, and that their estate is being handled the way they wish their estate to be handled. And again, it's always interesting. I always get many questions from clients where a parent has passed and that child was acting as the agent under the power of attorney. And that child may say, well, I'm acting as the agent under the power of attorney. I'll just keep doing what I have been doing. With a power of attorney, which is a legal document that says if I'm unable to handle my financial affairs, I'm appointing someone else as the agent or the attorney, in fact, to handle those for me. The power of attorney dies with the person, with the principal. So if I have a power of attorney, my husband has been taking care of my financial affairs, and if when I should pass, that authority under the power of attorney passes with me. So the agent under the power of attorney can no longer act upon my passing. So that job as the agent or attorney, in fact, again, dies with the person. The person can no longer act. So again, especially with their assets that might be in a brokerage account, especially in this day and age right now, the market is so volatile, we want to be able to file a probate petition or even an administration petition pretty quickly after the decedent's passing, and have those letters testamentary or letters of administration issued as quickly as possible to start protecting the estate. When there is an estate, when the decedent owned a brokerage account or stocks, and those stocks are volatile, many times, more often than not, will request that the court issue a document called preliminary letters, either preliminary letters of administration, if possible, or preliminary letters testamentary, saying, hey, court, we know that there are these volatile assets. We want to be able to marshal them and protect them quickly. Or court, we know the person just died, but there's already an offer on the house or on the co-op or the apartment to be sold. We want those letters very quickly in order to sell that asset or protect that asset. So it is very important when there are volatile assets or real estate to be sold, we can file a probate petition and request those preliminary letters. It's saying, hey, court, can you at least rush the beginning part of the process so we can protect the estate? So again, it's always so important to know how assets are titled. And we have many clients who end up making a folder that says, the Aeneas Scanlon Sirignano folder, elder law estate planning folder, which has copies of all their estate planning documents, but also lists of all the assets. where they're located, how they are titled, in order to make, for ease of management during lifetime, but also ease of management upon passing. One of the other reasons why sometimes intestacy is more difficult rather than when you have a will is because of digital assets, right? There are many online bank accounts, a Facebook account, a bank account, LinkedIn account, Spotify, and whatnot. So our wills, as do our powers of attorney, have provisions in terms of digital assets, also for ease of management for the executor of the estate in order to be able to marshal those digital assets as well. Or for example, Bitcoin. We know Bitcoin has become much more popular. How is a person supposed to be able to access, an executor able to access someone's Bitcoin monies unless they know that the Bitcoin monies are there? So it's very important to really keep a comprehensive list of assets, how they're titled, if they're online assets, passwords, though as we all know, passwords should be changed rather frequently. So again, upon passing, it makes the management of the estate go much more fluidly and with much more ease. I had a question here regarding funeral arrangements. This issue doesn't really come up with intestacy when a person doesn't have a will, but it really shouldn't come up when a person has a will as well. A lot of times a client will come in and ask whether or not they should have their directions regarding funeral in the will. And we always say no, because again, usually a person's funeral interment happens much faster than the probate or the administration of the estate. So funeral wishes, interment wishes should not be set forth in a will, but should really be in another writing, either a prepaid funeral agreement or in agent direction, burial agent direction agreement, as opposed to in a will. So again, it's very important to have funeral arrangements outside of the will. Many people also ask, should they store their original will in a safe deposit box? And I'll tell you, most of our clients have us retain their will. We have will safes and the original wills for safekeeping. We always discourage clients from putting a will in a safe deposit box because if a safe deposit box is in the name of the decedent, that safe deposit box is sealed upon the decedent's passing. So in order to access the safe deposit box, a petition has to be filed in the surrogate's court, first requesting permission to access the safe deposit box. So again, it makes it just a little more complex. Also, in terms of storing an original will in a person's house, we've had that where clients have moved, they've had their house, they downsized to an apartment, they downsized to another apartment and moved somewhere else. And unfortunately, at times, important papers, original documents can get lost. So again, we always, in our practice in our office, unless a client requests otherwise, we think it's important we maintain original documents in our office. But again, it's very important to keep a list for family members, a list of those assets, and also where your original documents can be housed. It's also important to, if a husband and wife or parent is doing a will and they do have a child or children under the age of 18, it is very important to also, before nominating a guardian in the will, to really seek that person's permission to make sure it's okay that they'd be willing to act as your child's guardian if, God forbid, something should happen to the parent or parents and someone else, a guardian, needs to step in if a child is under the age of 18. And people ask, how often should they be looking at their estate planning documents? How often should they be updating their estate planning documents? And I'll use my husband and I as one example, and then my parents as a second example. When my husband and I were married, of course, we didn't do any estate planning until our first child was born. It was actually about a year and a half after our oldest was born. It was right after 9/11. And they joke about the shoemaker's children having no shoes. I looked at my husband and said, look, I'm an elder law attorney. We really should have wills. And it was simple. We did very simple wills. He has 6 siblings. I have 2 siblings. We said, okay, this person should be the guardian. And we moved on. About 10 years later, 2 other kids later. So 10 years later now with 3 kids, we said, okay, we're more established in our careers. We really need to update our estate planning. and we decided, we updated who would be the guardian for the children, but also who would be the ones to be making decisions, not only the guardian in terms of, assets going into a trust, if God forbid both my husband and I should pass when the kids were under 18, at what ages should they be able to access those funds and whatnot. Now, my husband's in, I'm almost 50. He's in his 50s. We looked at each other and said, our youngest is almost out of the, almost over 18. We don't need really a guardian anymore. Now it's college and please God life after that. We really need to update our estate planning because our needs are different. Our family's needs are different. And we can fast forward another 10 or 15 years, more like 10 years, where estate planning documents should really be updated again. Because, at that point, you're looking at children getting married, grandchildren, and then possibly down the road, not that much longer after that, in terms of, it's not only just the estate planning, but also the Medicaid planning. So really, we really find that estate planning is a finite process that keeps going every 5 to 10 years, depending on a person's stage of life. It's not a one-off, well, let's do a will and then we're done. Because really it's let's do a will, let's see where our family is, and now look at our life again 10 years later, 15 years later, to see what changes need to be done. But also planning techniques have changed, documents have changed. For example, the power of attorney form, which many of you have heard about. The document that says if I can't handle my financial affairs, you're appointing somebody. In the past, 10 years, that form has been drastically changed to change it in terms of a gifts rider, how gifts are handled, what gifts are allowed, what gifts aren't, what powers we're giving to the agent. So it's really very important to do an estate planning checkup. I'd say, every 5 or 6 years, but do probably update planning every 5 to 10 years, if not more, depending on the stage of life, but also if there are any medical issues that have come about, to really make sure that the planning you've done really comports with what your wishes are. And a lot of times you will have clients come in, they're older, they're in their 60s or 70s, they have their children are all married, they have grandchildren, and they decide they don't like one of their children-in-law. Or they think their child is going to divorce that child's spouse. And they want to make sure, they want to make provisions to make sure that any assets are in a trust. So in case there's a divorce or whatnot, again, we're not going to get into the marital assets at this point in terms of a divorce, but they really want to make sure any inheritance is protected. Or maybe a child develops a gambling problem or a drug addiction. They want to know that there could be a trust in the will to protect those assets as well. So again, it's so important to really do that estate planning checkup and also really speak with your attorney about what your needs are now, what your wishes are now. And this is always an evolving process. So there are the rules of intestacy when a person dies without a will, as we discussed before. When a person doesn't have a will, how their assets will be divided up among their distributees, depending on who is surviving them. But as we said, there's really no control as to how you can dictate about those. It follows the statute. So really having a will and doing comprehensive estate planning is so much more important. So there's a question here in the current environment. How can you consult, draft, and implement estate plans, wills, trust, etc.? Peter, that's actually an excellent question. First of all, I could tell you our office at Aeneas Scanlon Sirignano, though we are all working remotely, we are up and running. We do most of our consultations either by conference call or by Zoom. So it's very easy to do a face-to-face meeting via video. We discuss person's wishes. We go through the various estate planning techniques. We then send out drafts of documents, which we can then review either again via conference call or Zoom. And then in terms of implementing the estate plan, signing documents, we have two ways of doing it. First, in keeping with social distancing, we can do an in-person outside. I do it in my driveway, or we have an attorney in our office who's up county. He'll do a signing in her driveway, again, in keeping with all social distancing, leaving documents on a table, and I prepare them. We put stickers on every page, sign here, initial here, all while myself or the other attorney, and we each have a witness with us, again, all in keeping with masks, gloves, and social distancing with Purell on the table, and any way that we can make anyone comfortable. or if a person is unable to leave the house. Governor Cuomo, we have what are called remote notarization, e-notarization. You can do notary and witnessing via Zoom, Skype, any kind of video conferencing. We much prefer it. It is a little more complicated, but again, it's so important to be able to get estate planning done, and not just the estate planning right now, but really those advanced directives of a power of attorney, a healthcare proxy, a living will, that we're very lucky in New York that Governor Cuomo has allowed us to e-notarize, e-witness, to be able to make sure that anyone who wants to be able to get their estate planning done can. And I'll tell you, when we went on to New York State pause back towards the middle end of March, our office, we've been drafting estate plans and getting those signings done because we're so aware, again, as we've said earlier and we've all heard, in these uncertain times, it's really important to have some certainty. And this is such a way that there's something that we can control and help a person control to give that peace of mind. So again, attorneys, we are doing remote Zooms, remote, we're doing conferencing, Zooms, conference calls, Skype, whatever means that makes a client comfortable. And then again, email is really, has been phenomenal with this. We still have capabilities of mailing things. Glad the postal carriers are still working. And again, we can still do signings and whatnot. And as much peace of mind that we can give somebody and give somebody some comfort and stability now, that's a job that our firm, Elder Attorneys, Trust and Estates attorneys are doing. And it is so important. I think it's unfortunately, my partner Anthony Ania talks about, pandemics and planning. We believe 365 days a year, it's so important to do planning. But I think a pandemic such as this, such as the COVID-19, has given us all a lot of time to reflect on not only, on what's important, but we're all trying to do those things that we've never gotten around to doing. And frankly, estate planning, many people put off because they feel that, and I've heard this, that if it's sort of like a jinx, if they do planning, God forbid, then something's going to happen. I see it as the opposite, that it's important to do the planning, to know that if something does, God forbid, happen, that your loved ones are taken care of and your wishes, you know what your wishes are, and you want to continue on with your wishes. I appreciate us spending this about half hour together. I know I started a little late. We had some technical difficulties. Chrome needed to update on my Facebook, so my apologies. Again, my name is Sarah Meyers. I'm a partner with the firm of Ania, Scanlon, and Sirignano in White Plains, New York. We also have an office in Somers, New York. Our office telephone number is 914-948-1500. We do have a receptionist working remotely, answering the phones, fielding calls, and getting messages to all the attorneys and staff. And my email address is s.meyers, S.Meyers, @esslawfirm.com. And we are all available for questions, comments, consultations. If there are any questions after this program, feel free to give me a call or shoot an email, and we can find a time to talk. Hope you all have a good rest of the day, and thank you for joining us. Bye-bye.